Well, for the Rural Radio Network, I'm Joe Gangwish. We're at the Senate committee hearing that took place Saturday in Lincoln, put together by Senator Deb Fischer of Nebraska on the Waters of the U.S. rule. And one of the folks testifying, of course, Justin Lavene, Nebraska Attorney General's office. And Justin, of course, you're with the you're the chief of the Agriculture and Natural Resources Bureau there for your Attorney General's office. So this is something very important to you. Talk about your testimony.
Basically, we testified from the viewpoint of the Attorney General's office in regard to the legal issues that we have and the concerns that we have with regard to this new rule and the potential effect that it'll have on state agencies for the various Clean Water Act programs that we have to administer. And so we have a lot of concerns that this is kind of an overreach for the federal government of coming in and trying to regulate in-state waters, of which they usually do not have any control over.
Talk about maybe some things you've heard from the folks in the state, and particularly what maybe some things that the governor has said about how this could, affect us here in Nebraska.
Well, I'm not really sure about the governor necessarily on that, but I do know from the viewpoint of the Attorney General's office, the concern is that both from the regulatory side with DEQ, but also the producers in the area, there's a great uncertainty of what this rule is going to do. And it appears to grab a lot more land and water in the state and put that under the jurisdiction of the Clean Water Act. By doing that, you have a lot more regulation of individuals and producers in the state, which really becomes problematic.
Well, and that's something that you wanted to drive home, and that was kind of the theme for today, too, was uncertainty.
And I think it is uncertainty. I think the big thing is that we've been regulating under the Clean Water Act with DEQ for the last 40 years with a current definition. And so to have this new definition come in, we're not sure how the Environmental Protection Agency is going to interpret that or how they're going to interject themselves into the state-run programs.
Talk a little about how this may violate a Supreme Court decision that had taken place earlier. Can you expand on that?
Well, yeah, the problem here is because you're going to have some basic categorical inclusions, if you will, of all these new waters, it does not appear to go towards the test that the Supreme Court has set out, and that is basically that to be a navigable water, you have to have some permanent surface water connection or at least a significant nexus to that body of water. And the problem is with this categorical inclusion of all these lands, you're simply not going through that analysis, and that's something that the Supreme Court said you had to do.
Well, Justin, from the Attorney General's office, where would you like to see this go from here?
Well, quite frankly, at this point in time, I think it might be important for the agency to take a step back and maybe reevaluate what they're doing, possibly have a little bit more consultation with the affected agencies in the state that are administering these programs for them, and kind of look at what are the specific needs of the states instead of trying to do a broad definition that covers everybody.
All right, Justin Lavene, he's from the Nebraska Attorney General's office at the Waters of the U.S. hearing that took place Saturday in Lincoln. I'm Joe Gangwish.